All right, this is case number 26CR43486, the State of Ohio versus Kevin Ashley. Mr. Ashley is before the court with Mr. Huss's attorney, Ms. Nicholson, on behalf of the State of Ohio. Ms. Nicholson, what are we doing?
Your Honor, the defendant's going to be entering a guilty plea to count 2, the grand theft as a felony of the 4th degree, and count 4, criminal trespass. The state dismissed the remaining 2 charges. There is no agreement on sentencing, but we talked in chambers. And I do have a victim impact statement from the victim if the court proceeds with sentencing today.
All right, Mr. Huss, is that accurate, sir?
That's correct, Your Honor.
All right, Mr. Ashley, they're telling me you're going to change your plea to 2 counts of the indictment to 2 charges. Before I get to your change of plea, I am required to go over some things with you, okay, sir?
Yes, sir.
How old are you?
How old am I? 53.
How far did you go in school?
I have a GED.
So you can read and write okay?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation that you've received from Mr. Huss?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medications that interfere with your ability to understand what's going on today?
No, sir.
All right, I have in front of me a document. This is called a change of plea. On the second page, on the line marked defendant, there appears a signature. Did you sign this?
Yes, sir.
Did you read over this and go over it with your attorney before you signed it?
Yes, sir.
Do you feel comfortable that you understand what it says?
Yes, sir.
All right. This document says you're under a plea of guilty to 1 count of theft as a felony of the 4th degree. That carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. The second count is one of criminal trespass, a misdemeanor of the 4th degree. That carries a maximum penalty of 30 days in the Warren County jail and a $250 fine. Do you understand the maximum penalties?
Yes, sir.
Now, you're also subject on this to a mandatory period of post-release control, which means that if you go to prison when you're released, the Adult Parole Authority may supervise you for up to 2 years. If you violate that supervision, the Adult Parole Authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
Now, you are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require at that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, you have the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense.
Your Honor, it's a matter of life or death that I succeed, that I get help. You know, when I leave prison to this time, when I you know, it really is, you know, it's either, you know, life or death that I get help or enter society. You know, I can't do it by myself. I'm asking to please, I was asking you to put me on probation, but now this deal's, that's not going to happen. In 2005, in a prayer, God told me to get out and give back, you know, because I had, you know, I've been doing a lot of bad, and to talk to average youth about what this life has to offer and what that they can expect. And then I get out and I want to go do my own thing, so drugs and prison is my will, like Jonah in the Bible. You know, listen, I figured that out this last time, and I want to start an organization, and it's called GANG. It's G-A-N-G. Giving adolescents needed guidance, and with the right frame of mind, I know I could do some good with that. And I just asked the court to take that into consideration.
All right, Mr. Ashley, you know, as I sit here and as we talk in chambers, and you sound like you're well-spoken. You sound like you, at least, you verbalize good intentions and the right things, but that doesn't really match up with what I'm looking at with your record. I mean, you literally have a record that spans over 30 years.
Yes.
That you've been stealing from people. I mean, if you want to change, if you want to make a difference, you have to make a choice to do that. There's nothing that prevents you from seeking whatever substance use disorder or mental health issue help that you need. You don't need the court to order that. You can always get that. And there are certainly programs available for you to get employment rather than stealing from people. Because when you're the victim of a theft offense, I can tell you personally that you feel very violated. It's a very personal thing to the person who's the victim. I'm sure this person would, number one, want his restitution paid, and number two, want me to send you to prison for 1,000 years. Well, that's not going to happen, and that's not realistic. But you know, I don't know what it's going to take. You say the right things, but you don't do the right things.
Right.
So. All right, the court has considered the statements made here today, the purposes and the principles of sentencing, including punishment, deterrence, and protection of the public. The court does find that you are not amenable to community control. The court does find that probation would not adequately punish you and would demean what happened in this case, and that prison is necessary to fulfill the purposes and principles of sentencing due to your extensive criminal history and your failure to respond to previous community control sanctions. So I'm going to order you to serve 15 months in prison. We got a jail time credit?
I believe it's 99 days.
99 days jail time credit. There's restitution in a sum of $15,809.04. Other than that restitution, the court does find that you're indigent for the purpose of any fines, costs, or other financial sanctions. As to the criminal trespass, the court will order you to serve 30 days in the Warren County Jail, that to be served concurrent with the 15 months. Now, you're also subject to this discretionary post-release control. Do you need me to go over that with you again?
No, sir.
Okay. There may be opportunities for you to receive up to 1 day per month for participating in certain programs that are sponsored by the Department of Corrections. And you do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. Do you have any questions for me?
No, sir.
All right. Ms. Nicholson, anything else?
No.
Ms. Huss, Mr. Huss?
No, Your Honor.
All right, good luck to you, sir.
Thank you. Okay. Good luck, Kevin.